Hello there, this is Frankie Prey. I am the employee rights attorney here in Newport Beach, and I'm making a presentation about your legal rights in the workplace, because that's what I do. Remember, when you're hired, you're happy, and when you're fired, well, I'm happy. Yes, because that's how I make my living, helping people who have been fired. Think about that, fired. It sounds like you just went up in smoke. And in a lot of ways, you do. And I try to put the pieces back together for you. In fact, we even try to make life better. We certainly don't want to make it worse. Hey, today I'm going to tell you about a new development in something called arbitration law. Why is this even important to you, right? Because of all those papers you signed when you were first hired, some of them probably included an employee handbook, and in the employee handbook there was probably a document or provision that was called an arbitration agreement. And basically it would say something like this: you got anything to fight about with us, you're going to submit it to an arbitrator outside of the usual procedures of a court. You won't have a jury, you won't have a right of appeal, and you may even have to pay part of the cost or all of the cost of the arbitration, depending on the nature of the claim. So this is a serious matter. But in this particular case I'm going to tell you about, this employer, like so many others, outsmarted itself. In this case, the employer put this provision in a handbook, and in the handbook, as it is often the case, the employer said this, actually wrote this: hey, we can change the handbook anytime we want. We don't need your permission. We don't have to give you notice. And we can do it at any time. And we can even do it retroactively. In other words, this is just a set of policies. We get to make up the rules. We can change the rules. Tough luck for you, Mr. Employee. Well, the Fifth Circuit of the federal court system, the Fifth Circuit Court of Appeals, found that this was the noose, and the employer had created it, and it was the employer's neck that was in it, and if this be execution, let the platform fall. Actually, they didn't write that, but something like that, in language that you would have appreciated if you had been a lawyer. Anyway, bottom line is this: the arbitration agreement couldn't be enforced against the employee, and the reasoning of the Court of Appeal was simply, hey, if you say you can change the rules, and the arbitration agreement is part of that agreement in changing the rules, well, that means that you can get out of arbitration anytime you want. You could say, as if you were the employer, hey, we don't like going to arbitration on this particular case. We want to go to trial, so we're just going to change the rule because that's what we get to do. The court said, nope, that isn't fair. In fact, that's not even conscionable. That is not even the basis of an enforceable, valid contract for arbitration. It is so one-sided. Result, the employee got to go to trial, got his jury, 12 people just like you who know what it's like to be fired, up in smoke, now get to decide, let's give this employee some money for these kinds of strong-arm, overbearing, domineering, irresponsible, and illegal activities. Let me say parenthetically, a footnote, I don't know if that's the case or not. This could have been a fine employer. Could have been the best employer a man ever had, or a woman. But let's assume that they are dastardly, evil creatures and deserve to have a full measure of damages awarded against them. Don't you think that 12 upstanding citizens like yourself are more likely to do that than would be a well-trained, very conservative, down-the-middle, analytical, heartless arbitrator? Oh my gosh, I just realized that when an arbitrator sees this, I don't have a chance in front of an arbitrator. So if you're watching this and you're an arbitrator, you are the exception to that characterization. So, bottom line, actually, second or third bottom line, call me. Get yourself fired first. That's very important. Make sure it's for illegal reasons in violation of fundamental public policy. And if you happen to sign a bunch of documents that require arbitration, bring those with you, or we'll get them for you from your employee personnel file, and we'll look over those papers to see if that arbitration agreement is actually enforceable. Because you would be surprised how many different ways an employer manages to screw up a valid arbitration agreement. That's all, folks.